Welcome to Sakshi TV special immigration talk show with an international lawyer, Mr. Srinivas Kaveti. Please note that Sakshi TV now has four immigration shows every week. On Tuesdays with lawyer Srinivas Kaveti, on Wednesdays with attorney Ms. Prashanti Reddy in English, on Thursdays with Mr. Chand Parvatneni, and on Fridays with Banu Nindra. Please tune in to ask your questions. If you are an immigration attorney or lawyer, you can definitely contact our Sakshi team. You can email us at usa@sakshi.com or call us at 866-725-7441. Before we begin the show, please note that the information provided on the show is not legal advice and for general information purposes only. Sakshi TV or its agents will not be responsible for the use of information. If you need any specific legal advice, you can definitely contact the attorney or lawyer directly. Mr. Kaveti's Kaveti Law Firm, has put a wealth of free information and online tools in the hands of the immigrant community. They are headquartered in New York City and across the globe. They have global footprints in Australia, Asia, Europe, and North America. They help individuals and companies deal with their legal matters, and their innovative approach to legal representation is the reason why they are a top-notch priority and top-notch choice to their clients. So without any further delay, let's welcome Mr. Kaveti. Mr. Kaveti, I hope you're doing well.
Yes, thanks, Shivani.
Yes, Mr. Kaveti. So today we thought we will discuss, this is a pretty important topic actually. So it is about the recession that is happening, and also because of the recession, a lot of people are getting layoffs, which is the H-1B layoffs. And today we will be discussing a little about the layoffs. We're also going to discuss about what are the special rights that they have. So yes, Mr. Kaveti Garu, can you give a summary about what exactly are we going to talk to our viewers watching the show?
Yeah, first of all, let's talk about the, what are the do's and don'ts for the employers, what are the rights of employees, those who are on H-1B or on L-1, and what are the rights of their dependents, those who are on H-4s or L-2s, what they can do, how long they can stay, what sort of rights they have after termination of employment, how many days they can stay in the country, can they change the status, can they extend the stay, what are the rights under the Department of Labor regulations, what are the rights under the Immigration and Naturalization Act, and what are the rights under the contract law. Sometimes the employer and employee has a contract, and sometimes they don't have a contract. So what are the rights under the contract law? So we would discuss all of that. And, what if they want to stay back in the country, can they find another employer? Or if they want to go back to their own home country, what checks and balances they have. Those things we can discuss in today's topic.
Yes. So Mr. Kaveti, let's get on to our topic really quick. So what exactly are the obligations of an employer when they are terminating an H-1B worker?
Shivani, one must understand that there are two types of employment. One is at a will, and second is it's not at will. What does it mean? Many times when the employers, they give you a job offer letter, and they also ask the employees to sign a contract. In the contract, it is said, employment contract, it is said that the employment is at will. What does it mean? At will means the employer can terminate the employee, and the employee can also terminate the relationship with the employer. That is called at will. Sometimes that is called with cause and without cause. What does it mean? The employer don't have to show a specific reason. An employee don't have to show a specific reason. They can just terminate the contract. That's called at will and without a will. And sometimes there is a contract between the employer and employee that the contract is for 2 years or 3 years because the employer spends money on training and the employer spends money on immigration fees, on immigration lawyers. So they would say, okay, you got to work for us for minimum term of 2 years or 3 years. If that is the case, then it is a contract law governs the employer and employee. So at that time, there are different laws applicable.
Yes. So, Mr. Kaveti, what are the rights of the employees when they get terminated? What kind of help can they get? And, what are some of the rights that, the people must know?
The first and foremost thing, there is an obligation on the employer because they're hiring a non-immigrant workers. They're bringing either people from overseas, from their home country, or they're in US, they're hiring them. Let's say somebody is on a student visa, they're hiring them and sponsoring them. So let's say that they're bringing them from overseas. The employer, first of all, has to give a clear notice to the employee, unequivocal. That means he's terminating the employment. They have to give a written notice, number one. Number two, they have to clearly settle the wages, saying that, okay, we owe you this much of money, so you please take this money and you can either go home or you can stay back and look for another employer, and they have to give a specific notice. And third thing, this notice of termination has to be a bona fide. That means it's not that they don't like the employee, they want to give a hard time to the employee, they just want to terminate. No, the termination has to be a bona fide. And four, if they have a contract, let's say if the employment is through a contract of 2 years or 3 years, and if the contract says that in the event the employer is terminating the employee, they will be paid a severance package. Severance pay is a pay given to the employee in the event they work more than 1 year. So, there are certain things which are governed by the contract. Sometimes it could be, repatriation funds, and the employer is obligated to give a notice saying, hey, if you want to go back to your country, we will pay you an airfare, or we'll give you a cash. You want to settle things with us, take the wages, take the bonus, take the severance pay, and you can go home. And the other obligation, what the employer has, they have to notify the USCIS. They're saying that we have terminated this employee, so can you please revoke the H-1B petition? And the sixth obligation the employer has, sometimes if they're bringing people from overseas, they have to report to the anti-fraud unit of the US consulate in the home country of the employee. And the seventh obligation is the employer is obligated to report to the Department of Labor because it is part of a labor condition application. So these are the obligations of the employer when they're terminating to the employee. Those are the obligations of the employer. And if you're looking at the rights, yeah, go ahead.
No, please continue.
Yeah, if it is, many times we get calls saying that, employees, whether they're on H-1B or L-1 visa, they get terminated. As you rightly said, we're getting a lot of calls these days because there's a lot of layoffs in IT industry now. So they're asking us questions. The employees are asking questions as to what are their rights. The first right they have is they have 60 days grace period. The immigration laws changed in 2017. After the termination, after the laying off, they have 60 days period, grace period, to find another employer. And the other thing is the employees have a right to choose another employer or change their status. Sometimes they want to stay, they want to pack up their baggage, but they want more time. So they can change their status from the H1 to a visitor's visa. Or some employees want to go back to school. They might want to get some training, or they want to upgrade their education or skills. They can find a school which is willing to give them an I-20, and they can apply for a student visa as well, which is called an F1. Because and there are some employees, those who want to get an H1, so now they come under the cap exempt, so they can immediately get another employer, file an H1B under the premium processing, start the employment. And there are some employees, those I-140s are approved, labor certification is approved. They have a right to find another employer for portability. That means they can shift their priority date to another employer. So, these are the bunch of rights the employees have. And, same rights they have for the employees' dependents, because they are on H4s. And sometimes, the employees' children, they are going to schools, colleges, and they sometimes want to get an F1 visa for their children. They want to go to a university, or they're already in a university, sometimes on an H4. So they want to get an I-20 and apply for a change of status to get an F1. So there are a whole bunch of visas available for these employees if they want to change their status within 60 days. So these are the rights for employees.
Yes. So, Mr. Kaveti, what are the options the employees have before they leave America?
As I said to you, they can get another employer, or if they want to go to school, they can get an I-1. They can get a F1 visa. If they want to just stay for another 3 months or 6 months because they want to wind up and go back to their home country forever, they can apply for even a tourist visa, and they can approach some immigration lawyers. They can ask for a change of status from an H1 to L1 to a visit visa. They would be granted another 6 months stay, so that if they decide to go back to their home country, they can go back. Or if they want to stay 6 months on a tourist and check out for another employer, they might get another opportunity in 4 to 6 months' time. So they might, get another H1, or they want to go back and get an L1 also, they can get an L1. Depends upon many factors. There are so many people. Let's say if somebody is coming from Australia, they can also get an E visa. And somebody is coming from Pakistan or some countries which are treaty partners, they can also change it to E visa. And there are some employees, those who have done some doctorates, or they have done their exceptional ability. They have some research papers submitted. They have some international acclaim. They can also apply for a green card under the extraordinary ability. So there are different options available. And some clients are calling us and saying, can we apply for a green card by investing some money? So they might have some savings. So they might want to invest $800,000 and get a green card through investors category. So there are a whole heap of things they can do.
Yes. So, Mr. Kaveti, you did give, like an introduction about what the employee must do when, they lose their jobs. So, can you in detail explain the process? Like, let's say that, someone has lost their job. So, must they go and tell the government, or the USCIS that, okay, listen, so I've lost my job. So is there any process, or like what legally what one must do, for a safe, saving their, whatever the problems are happening. So what can they do?
The first and foremost thing is, Shivani, there are no obligations on the employee. There is only an obligation on the employer. You know, they have to become, after 60 days, you become out of status if you're not taking care of your immigration status. So one must be careful, because once you become out of status and returning back to US or changing to another status becomes difficult, because they have to always be attentive on their immigration status. So if they decide to stay back, they have to approach some immigration lawyers, so they can even go online, apply for change of status. They should not pass 60 days. That's the first thing they have to do. And they also should protect their wives and children's interest. You know, in case sometimes their wives, they want to go to school. They're on an H4. They've been on H4 for a longer time. They want to upgrade their status and they want to upgrade their education and skills. They might want to get an F1, and the husband might want to go on an F2, or the children might want to go on F2 with their mothers, or the children might want to get an F1. So they have to approach immigration lawyers in their particular cities, or go online and find out, take care of their immigration status within 60 days. That is the key. And if they don't do it, they're running the risk of being out of status. Once you become out of status, that means you're jeopardizing your immigration opportunities in migrating, or even if you go back, you will not be able to come back again. So that's the most important thing for any of these H1 employees, or even L1A, or even TN visa guys. You know, because there are a lot of TN visa guys come to America from Mexico and Canada. And sometimes we have clients who came from Australia on E visa, E3, it's called. You know, even they're losing jobs. So they have to be careful of changing their status and taking care of them, their immigration status. They could go back, you know, because these TN visa guys who came from Mexico or Canada, they can go back and come back again. And even E3 visas, the Australian
Yes.
guys. So they got to take care of those things. That's very, very important.
Yes. Now, this is a doubt that I got, Mr. Kaveti. We did discuss in one of the show that once a child is born in USA, they are legally the citizens of the country. So, what happens to the children if their parents have lost their jobs? What do they have any special, any special powers, or do they have to move back to their parents' respective countries? So, what's the situation with the children?
Wonderful question, Shivani, because clients do call us and say, hey, our children were born in America. They're going to schools in America. Do we get anything based
Yeah.
on our children's status? The answer is no. You can only get status if your children are more than 21 years, they can sponsor you. But otherwise, if the children are minors, unfortunate thing, the children's also, they have to get a visa to go to their home countries. They have to depart the country with their parents. Unfortunately, because your children are American citizens, doesn't confer any immigration status to the parents. It's a brilliant question.
Okay. Thank you so much, Kaveti Garu. So, Mr. Kaveti, can you explain what exactly is this 60-day rule? And if so, is there, can people extend this 60-day rule if there is a special occasion, or if there is, or due to, some any other things?
Excellent question again. Yes, the 60-day rule is given, but there are certain exceptional circumstances or extraordinary circumstances. Let's say somebody becomes sick and one of their family members in the hospital, or they're met with an accident. There are so many circumstances, things happen in people's life. And of course, yes, if some employer is willing to file an application after 60 days, there is some reasonable delay in doing it. So yes, those things can be looked into by the immigration, but case to case is different. So that's based on the facts of the case. But there's no thumb and a hard and fast rule, but those are extraordinary circumstances. The law says that things beyond your control. Yes, of course, yes. It can be extended, but
Yes.
depends upon facts of the case.
Yes. So, Mr. Kaveti, we did talk about the rights of the people who, whose jobs get laid off. But what about the people who are their dependents? What special rights do they have? When it comes to the, when the person who is owning the dependent family, they get their jobs laid off.
Yeah, wonderful question again, because many times these days you can see that husbands are on H-1B and wives are on H-4 or dependent spouses. And because their I-140 is approved, so they have a legitimate interest in the country, and they have a work authorization, EAD, work authorization of H-4s. What would that happen to them? Unfortunately, because it's a derivative of H-1B, they would also lose their H-4 status if they don't take care of it within reasonable time. The question is, will the EAD get revoked? There is no automatic revocation of EAD, work authorization, but it is the duty of the H-4 dependents that after 60 days, they would lose their right to work in the country, because that EAD, work authorization, or the derivative status of H-4 is based on the principal applicant. That means if the husband is not around with any job, so automatically the spouse also loses the right to stay in the country and right to continue her employment in the US. So that's an unfortunate thing. The second thing is, if they want to do it, they can only do under the humanitarian grounds. Sometimes what happens, there are many cases, there are battered spouses. The wives are tortured by husbands. Under such circumstances, H-4's battered spouse, under the H-4 battered spouse, their EADs can be extended. Their children can be under the status of H-4 on the dependents. That's the only case where the wives can extend their EADs and they can stay in the country. Other than that, there are no other situations.
Yes. So, Mr. Kaveti, like you yourself are an international lawyers, and you go around different countries in the world, and there are also something called as the unemployment benefit programs that happens, especially in USA. So, can these people who got their jobs laid off, can they get any advantages or maybe benefits from these unemployment benefits programs?
Excellent. Yes, unemployment benefit is an insurance you pay when you are employed. If any of these H-1B employees, they look at their pay stub, there is an insurance paid called unemployment insurance. So yes, they can claim unemployment insurance up till 2 months, because 60 days you have lived in this country, you paid for that, you can claim unemployment insurance. But after 60 days, you're running a risk of immigration law, so you'll have to leave the country. But yes, you can claim unemployment insurance. As I said initially, if there is a contract, and if in the contract, if the employer agreed to pay a severance pay, the employees are entitled to severance pay and repatriation funds. Other than that, no. Up till a couple of months, they can claim. But this unemployment insurance is very common. People who are on a green card and citizenship, they claim unemployment insurance. But there are certain laws, because it's a state law, and they're not going to give you forever. You have to make certain efforts and show to this unemployment insurance or unemployment benefits to the state that you've been trying a job, but you didn't get it. There are different countries, as you rightly asked me a question. It's called dole in Australia. It's called Social Security benefits in England. And same, Canada is also has that similar situation. So these countries, they do give unemployment benefits to people who are not employed because they have to pay the bills. But in US, on an H-1B worker can also get unemployment benefits for only a couple of months, because if they live more than 60 days, they're running a risk of immigration, being an out of status. So yes, they can.
Yes. So, Mr. Kaveti, what exactly is the severance pay? And you did talk that, when one is signing their offer letter, there is something that they mention that, they will have a severance pay. My other doubt is that when will the severance pay, get offered? Like if once the 60 period is done, or once they when they stop starting, that is when the company pays the severance pay.
Okay, very good question again. Severance pay, there is no reference of severance pay in immigration law or in the Department of Labor regulations, but there are certain laws governing the employees called employee benefit law and stuff like that. In H-1B employment, non-immigrant workers, only when the employer is stating specifically in the contract that we'll pay you a severance pay, then only the employees are having an entitlement of getting a severance pay, not otherwise. One must understand. And second thing is, the employees are entitled for severance pay if the employees worked for a certain period of time. Most of the time, it's more than 1 year or 2 years. Every state, it's a different thing again. So it's a state subject again. So that's the only time. Normally it's like 2 months or 3 months wage they pay before they're terminating the employment. It just to give a cushion for the employee to pack up their baggage and go. Otherwise not. So these things are negotiated initially when employer and employee are signing a contract, but not otherwise. So these things are again at the option of starting the employment. I'm sorry. Yeah.
Yes. No. My doubt is what is repatriation funds? Is it different from severance pay?
Severance pay is something different from repatriation funds. Repatriation funds is the immigration regulation says that you're bringing somebody from overseas as a foreign worker, you're terminating him, poor chap or poor woman, they came with a dream working, they're going to work for you for 3 years because of your business, commercial impossibility, you lost business or you lost contract, you're sending them home. So you better pay them airfare to go home. Either you pay them cash or you give them an airfare so that they can go back to their home country. The unfortunate thing is the law says they have to only employee gets paid, not the entire family. That is called repatriation fund.
Okay. So finally, Mr. Kaveti, can you tell us what are some do's and don'ts for the employee when they are, to avoid the being out of the status?
As I rightly said, I'm sure a lot of H-1B employees and L-1 employees and TN employees and E-3 employees know the situation. They just have to, not go out of 60 days grace period. And if they want to stay in the country, if they are trying for another job, if they don't see any light at the end of the tunnel, they have to file an application for a change of status or extend their stay to another status. That's the only thing which I can see to take care of their immigration status. Or if they have a plan, they should go, many times what employees have, they also have B1, B2 visa. They can go out of the country and come back on a B1, B2 visa, or they have to apply for another status of F1, or if they get another employment, file an extension and change of an employer, H1 again, things like that. So that is the only thing which I can see at this stage. And as I rightly said, if they have really a lot of money, they can apply for a investor's visa. But not many people have $1 million. Some people have, while they're in America, they have completed their doctorate or postdoctorate. They could even try for applying under the extraordinary ability for a green card in the country. Sometimes, spouses, they come and complete their master's, PhDs, and they have doctorate degrees, and they can also apply for a honorary doctorate. And there's people, they also get J1 visas. They can also get teaching jobs, things like that. they should apply those visas. They change of status can be done. And premier processing is also there. They can take
Yes.
away those opportunities. Yeah.
Yes. Yes. Thank you so much, Mr. Kaveti, for joining on to our show. We covered a very important topic. Thank you for the viewers for tuning in. You're watching Sakshi TV with me, Shivani Raj.
Thank you, Shivani.